Hi everyone, I'm David Glazer, and I'm just going to do a quick introduction of our people here and a few fast announcements. So first, for those of you who are frequent webinar listeners, you may remember that Jim and Katie Douglas did this webinar in 2006. So this is like the 9-year anniversary of that. But just a few quick announcements. So first, our next webinar, which will be in 1 month on June 10th, Katie Ilton and I will be talking about internal investigations, self-disclosure, and things like that. And actually, at the beginning of that webinar, we'll quickly introduce Joe Dixon, who's the newest member of our group. He joined the White Collar group, and we'll talk about him a little bit on June 10th. Then in July, Catherine London and Bob Klipinski will be talking about clinical trial agreements. That'll be July 8th, and we're going to have a second webinar in July. Let your HIPAA people know. We'll be talking about big data breaches and other horror stories and what you learn from them and how to implement a data response plan. So finally, we know that the internet sometimes slows down over lunch. So you can listen to us free right now over the internet. If you need to dial in the chat box, there's a number. If the sound goes to heck in a handbasket, you can dial in with the number that's in the chat box and use that. So, with that, I'm going to turn it over. So we've got Jim Platt and Katie Douglas, who are two of the best people in our group. I think it's just getting stuff done. That's one of the things they are our genius accomplisher lawyers, and they're going to talk about professional services agreements. So I don't know. I am lucky to work with these guys because they bail me out of trouble all the time. So Jim, take it away.
Thank you, David, and thank you, folks, for listening and participating in our webinar today. I'm going to be talking about professional service agreements. I'll talk here a bit at the front end, and then Katie will follow me at the end. We'll do a couple back and forths in between. And as always, we invite your questions. Type them in the chat box, and we will save some time at the end to go over those. So, professional service agreements. So here's what we're going to be talking about. So I'll talk about what are they, why do we use them, what are the critical terms, and Katie will talk about what laws are relevant. So what are professional service agreements? I'm sure most of you listening know what these are. Sometimes they're called medical services agreements, professional service agreements. It's really not anything particularly legal or unique in the name, but most of the time you see these things called professional service agreements, or PSAs. They are agreements between two healthcare providers for the provision of medical services. They can range from anything as simple as a medical director agreement to agreements for things like emergency room coverage. It could include an agreement between a hospital and a group of anesthesiologists to provide services at the hospital. And it can also include primary care groups that have specialists who come to their practice and treat patients. And it can include hospital physician agreements either for a particular service line, like the hospital wants to contract with a group of physicians on an oncology service line, or it can include the entire clinical practice as part of an asset purchase agreement. So a hospital might acquire all of the assets or some of the assets of a physician group and then contract with the physician group to provide services under the professional service agreement. And it's really this last category, a professional service agreement used in the context of an asset sale of a clinic, that I'll be speaking mostly about. Although a lot of the things in terms of the laws and terms to think about are going to be common with all of these. So why do we use professional service agreements? Well, for a variety of reasons. One reason is that it will streamline the billing process because you're going to have one organization, the health system, that will be billing governmental and private payers for all of the services that the physician group is providing. So the idea here is that payers and patients will receive one bill for all of the services that are being provided, not one bill from the doctor group, one bill from the hospital group. And with that is a hope that that would be more efficient, less costly, more effective. The second reason is that it affords an opportunity to expand services to patients. There may be a situation where a hospital is interested in providing some new specialty services to patients, but the doctor group isn't willing to take the financial risk involved with that. So the hospital may say, look, we'll bill for your services, we'll take the financial risk, and we'll pay you under a professional service agreement to come in here and provide those services. That makes the doctors more willing to do it, makes the hospital excited because it can now provide this new service, and patients obviously benefit too. So it's an opportunity to expand services to patients by providing some shifting of the financial risk and greater flexibility, as I said, in terms of billing and hope for lower costs. The other couple of reasons for a professional service agreement is that it's in the context of the asset sale. So as most of you know, or I'm sure all of you know, there's been a lot of consolidation over the past 10 plus years where medical groups have become part of health systems, and one of the models that is often used in that regard is a professional service agreement. The other model is an employment model. So with the professional service agreement, the doctors do not become employees of the health system. Instead, the doctors continue to be employees of their professional group. They might set up a new professional corporation, but the point is they're going to stay employees of their own legal entity as opposed to becoming employees of the hospital. But other than that, it's an asset sale. All the assets of the clinic have been sold, and the doctors in the future won't have any assets in their practice. They'll simply be employed by their corporation. The hospital will do all of the billing, will collect for all the services, and will pay over to the doctor group a negotiated amount for their professional services. It is that professional service agreement model that is increasingly becoming common. The employment model is still used in a lot of places, but professional service agreements are also being used, and in my practice I'm seeing more of these of late than the employment model. One of the reasons why the professional service agreement model is attractive to physicians is because they may have apprehensions about becoming employees of the health system. Maybe not so much in a large metropolitan area where the physicians already have been employed by the health system, but maybe more commonly in rural areas, in a small community where there's a small rural hospital and a group of doctors. You know, the hospital, they know each other. They may work well together, but the doctors really don't fancy becoming employees of the local hospital and, in their view, becoming employees of the hospital CEO. So the doctors like the ability to be employed by their practice entity, have that entity contract with the hospital, and therefore give them a bit of insulation between themselves and the hospital. So some autonomy for the doctors is one of the desired benefits and one of the benefits that a PSA may offer the physician group. Another benefit, reason why the PSA might be used, is that on occasion the doctor group may have better benefits. Maybe they have a better profit sharing plan and they put more away toward their retirement than what they would receive if they became employees of the hospital. So the PSA affords them the opportunity to do that. And lastly, and I think significantly, a PSA provides a doctor group with the ability to collectively renegotiate the PSA when the term of the PSA comes due. So PSAs will have a term, PSAs will have compensation provisions that are going to need to be updated. And one of the advantages of a PSA for a doctor group is that it allows the doctor group to sort of renegotiate that whole package together. Whereas if they were all individual employees of the hospital could decide that it will negotiate with this doctor or that doctor and pick and choose, which doctor it's going to sweeten or change the compensation model with. So those are three reasons why PSAs are used, and I think increasingly used, as a vehicle to create integration with doctor groups that still have apprehensions about becoming employees of the hospital. So what are the critical terms of a PSA? Well, in no particular order, one of the critical terms is how long do you want the PSA to last? Now, PSAs like a medical director agreement, something as simple as that, those are going to be short term. They're going to be a year or two, typically not much longer than that. Even a service line agreement like the medical oncology service line type agreement, that's going to have a relatively short term, maybe a year or 2 or 3. But when you've got a PSA that involves an entire clinical practice where it was in lieu of employment, hospitals acquired all the assets, doctors going to provide services, you tend to see a term of that kind of a PSA being much longer. Years ago, these would be a 20-year term, and maybe even longer, a 30-year term. Now I see terms of these PSAs being much shorter, maybe 5 years for a term. And why is that? Well, I think one of the reasons is that there's so much change going on with healthcare reform, nobody can really say whether in 10 years we'll still have a PSA, whether it will even make sense. So a 5-year time frame tends to be about as far as health systems will want to go in terms of doing a PSA, because it just becomes real difficult to know for sure whether this model is going to be the kind of model that people will want more than 5 years from now. And frankly, for many health systems, what they would really like to accomplish is to have everybody employed in some sort of a uniform structure, not have some of the doctors employed, some of the doctors in one PSA, other doctors in another PSA. You can do that, and obviously if you need to do that to create integration and affiliation, you will, but over the long term, having different people under different arrangements just makes things complicated. So from a health system perspective, they're not going to be too excited about having a 10-year term. Maybe a 5-year term feels about right for them. So that tends to be where you end up with your PSAs, about 5 years for doing a whole practice. Now, one of the other things about the term is that is it a hard stop term? In other words, at the end of 5 years, is the agreement done? Is it over? Or is there an automatic renewal? We call those evergreen contracts, where the contract automatically renews at the end of a term for some renewal term. That's an evergreen contract. So what are the pros and cons of a hard stop versus an evergreen contract? Well, the negative about a hard stop contract is that absent a new agreement, it's coming to an end. It will end. And at the point where it ends, if you haven't worked out a new agreement, the doctors have no obligation to provide any more services. The hospital has no obligation to pay them. So it's kind of like a nuclear bomb will go off at the end of the hard stop. And that can put a lot of pressure on people on both sides of that spectrum in terms of negotiating that agreement with that looming on the horizon. Another aspect of a hard stop that us lawyers don't particularly care for is that it has happened, surprise, surprise, that clients blow past hard stops, not even really realizing that the contract terminated. So not so much in these giant PSA deals, but maybe in some sort of a smaller medical director or a call coverage agreement or something like that. It had a hard stop. It terminated. But the parties just kept on going. They didn't realize it terminated. So now you've got a potential Stark problem because your written agreement has expired. There's no written agreement to renew it, yet money is still changing hands. What Stark exception does that now fall under? May not fall under any. So, we get a little nervous about hard stop contracts where people will blow right past that date and keep on paying as if the contract was still in place. Now, evergreen contracts. Evergreen contracts, I tend to like them better. We don't have that hard stop scenario. And the other thing to think about with an evergreen contract is that one side or the other is going to have to say, we want it to end. Otherwise, it's automatically going to renew. So that creates an interesting dynamic. If you've got a PSA and you're in a small community, you've got the hospital, you've got a group of doctors, and one side or the other is going to have to say, we want it to end in order for it to end. Otherwise, it's going to continue to renew. So who does that put the pressure on? Would that put pressure on the hospital that it wants it to end, but it really doesn't want to have to give that notice? Well, then it's going to continue to renew. Or does that put pressure on the doctor group that this is a lousy agreement and they really want it to end, but they don't like the politics of having to announce that they're going to end it? So with these evergreen deals, you just have to ask yourself, what's the dynamic on that when it comes time to give notice? Does that put any kind of pressure on one side or the other to keep the thing going because they don't like the heat of having to give that notice? That's term. Termination rights, every PSA is going to have a for-cause clause that if the doctors don't perform under the agreement, then the hospital or health system can terminate it for cause. There's usually a cure provision, allowing the physician group an opportunity to cure it. One of the things about PSAs that can get cumbersome and clunky as compared to employment is dealing with physicians who really aren't pulling their weight. So you've got a PSA. The PSA is with a clinic. Let's just say the clinic employs all of the doctors, including specialists and primary care doctors. And so the hospital has an issue with the surgeon. The surgeon's really not pulling his or her weight. Hospital's not very happy with the surgeon. Well, with an employment model, the hospital can say to the surgeon, look, doc, this just isn't working. We're going to have to let you go. Or here's a performance improvement memo. You got to get with the program or we're going to have to call it quits to this. Your traditional kind of HR employment kind of situation. Well, with a PSA, it creates a bit of a clunky process. So what has to happen here is that the hospital says to the clinic, hey, clinic, we've got a PSA with you, and one of your doctors that you employ, the surgeon, isn't working out. The surgeon's not cutting the mustard. So we want you to take care of that surgeon, get that surgeon to do what we want the surgeon to do. Well, the clinic board of directors may say, well, we don't know anything about the surgeon. I mean, we're a bunch of primary care guys. We don't really see him operate. We really don't think that's something we're very comfortable dealing with. Why don't you deal with it, hospital, as a medical staff matter? Well, the hospital then has to go through the medical staff bylaws, has to go through the medical staff process. That's a whole different kettle of fish. So it makes dealing with these HR issues clunky and cumbersome. So I'm getting back to termination rights here, folks. So what typically will happen in a PSA is the hospital will say in the PSA, look, if we have a problem with one of your doctors, we have the right under the PSA to tell you, clinic, that you're going to terminate the services of that doctor. You're going to suspend that doctor because we're not going to pay for him anymore because we don't think that doctor's cutting the mustard. So, and if you don't terminate that doctor, clinic, or deal with that doctor, or suspend that doctor, then we're going to terminate this agreement for cause because you have not followed the agreement. So that's an example of how a for cause termination right can kind of be used to create some leverage or pressure to cause the clinic in a PSA to deal with these clunky physician termination situations. There may also be a without cause, meaning you don't have to give a particular reason, you just want the deal to be over. With longer-term PSAs, we used to see these sorts of things where one side or the other could give 1 year's advance notice that they're going to terminate at the end of the year. Now that we end up with PSAs with shorter terms, like 3 or 4, 5 years, I don't see as many of those anymore because people are just going to live with the 3-year deal. And if they don't like it, they'll exercise notice at the end so it doesn't automatically renew under an Evergreen clause. Exclusivity. So this has to do with whether the primary care group, in my example, is the exclusive provider of all primary care services, or will the hospital health system be able to employ other primary care providers? And where this gets interesting these days is with extenders. It's no surprise that people are thinking about how to reduce healthcare costs, and perhaps if we had more mid-levels, more PAs, more nurse practitioners, if they were on the front lines dealing with primary care services and seeing patients, then maybe that would be cheaper, less expensive than having a whole bunch of primary care doctors. And in rural areas, tough to recruit anyway, so maybe if we had more mid-levels. Well, if the doctor group under a PSA has the exclusive to provide all primary care services, and that includes mid-levels, well, then the hospital won't be able to employ the mid-levels if the PA has the right to do that. So you have to think about exclusivity and how far the exclusivity should go. What we typically do is we say that if the hospital has a need for additional primary care providers, maybe mid-levels, and if the clinic does not want to provide those mid-levels, then the health system or hospital can, on its own nickel, do that. So oftentimes you'll see it. It kind of gives the clinic sort of a right of first refusal to provide it if they want to provide it. If not, it can be provided by the hospital. You can imagine in the specialty area how this can also become sort of a contentious issue that gets negotiated in these PSAs, because maybe the hospital says, you know, we'd like to have 4 surgeons, not just 2, but the 2 surgeons who are already there say, well, you know, that's great, but I'm not going to have as much work to do, and I'm not going to get paid as much, so I don't like that. So does the hospital have the right then to say, well, we gave you, clinic, the right to have first option to employ 2 more, but you've declined, now we can go ahead and do it. That has to do with what the PSA says about exclusivity and how to react to those kinds of situations. All right, payment. So under the payment term comes a bundle of different things. The main thing about the payment term is what is the clinic going to be paid under the PSA? What's going to be paid? This is the most difficult thing right now to put into a PSA, because PSAs in the past have been set up and are still being set up to pay the primary care doctors or the specialist doctors based on their work RVUs. So, you know, there's a 2-year guarantee. Salaries won't fall below what the doctors had before they sold their practice. But you know, there's also this conversion factor. So they get paid a negotiated conversion factor times their work RVUs. Well, how long is that going to last? I mean, is that going to be a 5-year deal? You know, health systems are going to say, boy, we're not being paid as much based on work RVUs anymore. We're going to be paid in all kinds of different ways by CMS and private payers. So do we still want to pay the doctors based on work units when we're being paid based on other measures? So figuring out what the PSA is going to say about what the doctors are going to be paid under a 5-year PSA, when you really don't know what those things are going to look like, is a really tricky thing right now to figure out how to write it. You know, you can pretty much write that you're going to be paid based on work units for the next couple years, but after that, these PSAs are probably going to say that the parties are going to sit down and mutually negotiate what the PSA payment is going to look like for the rest of those PSA terms annually. Because frankly, nobody really knows what's going to work out there beyond, you know, a couple-year time horizon. So that's often and typically what you see. That drives some lawyers crazy, I'd probably be one of them, because I like the contracts to be nice and clear about what's going to happen, but you just can't forecast that. So you end up with a PSA that says, well, we're gonna work in good faith to renegotiate these rates in 2 years. Great, wonderful. What if you can't? What if you can't reach agreement? Hospitals bought all the assets. Doctors, you know, don't bill anymore for their services, and you can't reach agreement. Something's going to give here, because you're either going to have to continue under the old rates, or the deal is going to terminate and you're going to face the nuclear meltdown option. So the PSAs are going to need to include a lot more language and a lot more process about how to resolve these disputes. I can envision in the next few years these things starting to almost look like, you know, baseball arbitration or labor law collective bargaining type situations, where maybe you bring in a mediator and is going to mediate between the two sides to come up with what the payment model is going to look like. Maybe there would even be binding arbitration, where somebody gives a high, someone gives a low, and the arbitrator has the authority to settle between a high and low. But you're going to end up having to come up with something in the PSA to deal with the fact that you may not have easy agreement between the hospital and the doctor group on what the renewed payment deal is going to look like in those years 3, 4, and 5. Like I said, these things could end up having the feel of sort of a collectively bargained rate as these things evolve into the future. Non-competition. So typically, if the hospital purchased the assets from the doctors, it's going to want the doctors to sign a covenant not to compete because it doesn't want all the doctors to quit, set up a new practice again, or worse, join another health system, and then put leverage on the hospital for it to join that other health system. So they want the doctors to agree there's going to be covenants not to compete. But, again, this isn't employment. So the covenants not to compete are between the doctor and their clinic. And then the clinic agrees with the hospital to enforce those covenants not to compete. Well, what if the clinic didn't? I mean, what if the clinic didn't enforce the non-compete? Or what if the clinic said to the hospital, look, we'll do it, but you're going to have to pay for it. I mean, this is going to cost us legal fees, and that's not in our PSA payment. So enforceability of those covenants not to compete when it comes through the PSA is an issue that you have to take a look at under your state law and figure out how those things are going to work and who's going to be paying for it. Non-solicitation, no hire clause. The no hire clause deal comes up where if the PSA terminates at the end of the term, is there a clause that would prohibit the hospital from employing those doctors who want to go to work for the hospital? Here's the scenario. So the PSA is going to come to an end, or one side is given notice that it won't renew. The clinic wants to keep folks in the fold because they want to renegotiate a new deal with the hospital. They don't want the doctors to jump ship. If they start jumping ship and go to work for the hospital, the whole thing's going to collapse. So the clinic wants the hospital to agree that it will not hire any doctors for a period of 1 year after termination. That way, the clinic can keep everyone in the fold, renegotiate this agreement in strength. Well, you can imagine it from the hospital or healthcare's perspective. Well, if a doctor wants to jump ship and the agreement's coming to an end, they ought to be able to jump ship. So what the PSA says about that when a PSA ends is important in terms of how the leverage plays out when you try to renegotiate the thing after the end of its term. Again, something else that you have to think about in going in these PSA agreements. Performance standards, they're going to have a lot of things in there about bonuses being tied to quality measures, other critical terms that I don't have up here, but dispute resolution, I kind of talked about this, mediating it, non-binding or binding. What a lot of people are doing now when it comes time to renegotiate the pay part is they find that it's beneficial to bring in a third party to help negotiate the pay rates. Someone who's got some experience in compensation, has access to compensation surveys, knows what other health systems are doing, can help a lot, especially with folks that are dealing with each other day to day and in looking for solutions that both parties can accept. And the last little item to mention here before I turn this over to Katie is unwind rights. So an unwind right is a right under the PSA where the doctors can buy back the practice if it's going to terminate. Well, I used to include a lot of unwind rights, and then I said to myself, how realistic is this? The doctors sold all of their assets, 5 years ago. They don't own any equipment. They don't own any furniture. They don't have any billing equipment. And of course, in the last 5 years, the hospital has improved some of that stuff. So now the PSA is coming to the end, and the doctors want an unwind right to buy back that stuff. Well, the stuff has changed. They're going to have to pay fair market value to buy it back. The doctors that have joined the clinic since then, they don't have the money to buy it back. How valuable is a buyback right? Well, there may be some value there. Maybe the doctors won't buy it back, but maybe another health system will loan the doctors money to buy it back, then they can be employed by that health system. So buyback rights, the doctors will probably never go back into private practice themselves, but maybe somebody else might exercise that buyback right for them. So something to think about with buyback rights. The last thing you could do with an unwind is maybe you don't sell some of the critical assets in the first place. Maybe instead of selling, say, your building, you lease the building. That way, if the PSA is going to come to an end and you want to buy something back, you don't have to buy back the building. You've got the building. Or maybe instead of selling all of your furniture, fixtures, and equipment, you lease the furniture, fixtures, and equipment. That way, if something blows up, the PSA is going to come to an end. You didn't have to buy it back. You owned it, and you just rented it in the meantime. So how you deal with unwind, and do you sell the assets at the front end, or do you lease them instead in case it blows up? That all has to go into what you want to do with unwinds. Okay, so those are critical terms. Now Katie's going to talk about regulatory issues.
Okay, thanks, Jim. Switching gears a little bit from the business terms to the regulatory considerations that need to come into play when that will affect the business terms. So first we'll talk about kind of a whole host of federal laws that will impact how you're going to structure a PSA. There are requirements regarding reassignment of Medicare payments. If the PSA is between a group and a tax-exempt entity, then there are also laws that the tax-exempt entity will need to comply with that will affect how the PSA is going to be structured. The federal anti-kickback statute and the federal Stark law are also laws that are very important in structuring these PSAs. And then we'll also touch briefly on state laws that may also come into play, depending, of course, on which state you are in. Okay, so the general rule is that you can't reassign payment that you receive from Medicare for Medicare services, that you can't reassign those payments to another entity or to a third party. There are, however, several exceptions to this prohibition, one of which is applicable to the assignment by a non-employee physician to an entity with which the physician has a contractual relationship. And there are basically two key elements to the exception. First, the physician and the entity that's receiving reassignment are jointly and severally liable for any overpayment liabilities regarding or relating to the claims. And the second element is that they both have joint access to all claims that are submitted in connection with the reassignment. So another key reassignment issue that's becoming more important is what to do with meaningful use payments. So the default is that meaningful use payments are made to the individual practitioner, not to the entity that employs the practitioner who may be in an independent contractor relationship with the practitioner or with the physician. But Medicare does allow an eligible provider to assign its right to receive meaningful use payments if the eligible provider has a contractual relationship with that entity. So that's something that you need to make sure that you address in any sort of PSA is what is going to happen to the meaningful use payments if those are going to be reassigned, in this case to the health system. It's also important to note that you can only reassign assign your right to payment to one entity. So, if you're not doing a full PSA, in the kind of asset deal situation, the physician may have already, assigned the meaningful use payments to the physician group. So in that case, would not, also assign it to the hospital.
I'm going to talk just a second about taxes, and then we'll jump back to Katie a second. One of the other regulatory requirements is that if you're dealing with a tax-exempt hospital, a 501c3 hospital, or a 501c3 health system, they have to operate exclusively for charitable purposes. There's some significant IRS tax penalties if the hospital has engaged in a transaction where more than fair market value was paid. In fact, worst case scenario is that the hospital would lose its tax-exempt status. One of the things that can come up with PSAs is that sometimes PSAs have bonuses that are designed around the hospital achieving, certain financial goals, certain bottom lines. And you just have to be careful that you're not agreeing to pay over a percentage of the net income of the hospital, because the net income of a tax-exempt clinic or tax-exempt health system hospital cannot inure to the benefit of private individuals like physicians. Inure meaning paid over to. So you have to be a little bit careful about how you design financial incentives in PSAs to not run afoul of that. Tax-exempt bonds Once in a while, you'll run into this issue where if you're dealing with a tax-exempt built facility, so doctors are going to be having use of a tax-exempt built facility. It's probably the hospital building itself. Then there are some requirements on what the term can be of that PSA. So, for example, you know, if you had a group of anesthesiologists, they have use of the hospital's facility, that's a tax-exempt bond financed facility. There's going to be some regulatory requirements about the hospital being able to terminate that after a certain period of time to comply with the IRS safe havens for tax-exempt built facilities. Other tax issues, I'll just mention this one. I don't have a slide for it, but it's important to bear in mind. And that is the issue of, are the doctors employees or independent contractors? So PSA model, like I said, the doctors are employed by the PSA, and their clinic is continuing to pay FICA and FUTA on their compensation, but they don't have any overhead anymore. They don't own any equipment. They don't have any staff. They don't have any furniture. They don't have any billing. They don't have any of that stuff. And you know, when you talk to employment law folks and tax folks, they say, well, the IRS has a 20-factor test in determining whether an individual is an employee or an independent contractor. And so under the 20-factor test, you know, you would say, gosh, you know, it doesn't feel like many of those factors are present with a PSA. Now, with a PSA, though, the doctors are employed by an entity. They're not independent contractors personally of the hospital. So you would be hoping that the fact that there's an independent entity in there, their clinic, would save you from being reclassified by the IRS as employees of the hospital. Why would you care? Why does this even matter? No one's cheating the government out of FICA taxes. They're still being paid. The issue would frankly have to be with the doctor's employee benefits. Because if the doctors were reclassified as employees of the hospital, then whatever they were contributing to their qualified retirement plan, pension, profit sharing, 401k, those are not qualified plan contributions, and their plans would be disqualified because they aren't employees of their corporation. They would be deemed to be employees of the hospital. So that would be a disastrous solution. So when you're designing your PSA, you have to have in the back of your mind the fact that the IRS has a 20-factor test and that you don't want the PSA to start looking and smelling like it really is just an employment agreement. Okay, now back to Katie.
Okay. So moving on to the Antikickback statute. So this is a statute that prohibits the payment of anything of value in return for the referral of services that are reimbursable under a federal health care program, such as Medicare. This is an intent-based statute, which means that the payment must be intended to induce referrals. And in determining whether a payment violates the anti-kickback statute, the government applies what's known as a one-purpose test. This means that the government will look to all of the purposes of a given payment, and if even one of the purposes is to induce referrals, then it will violate the statute, regardless of any other legitimate purposes the payment may have. The anti-kickback statute is a criminal statute. Violation constitutes a felony and can involve fines of up to $25,000 per violation, imprisonment, and exclusion from participation in federal health care programs. So it's a serious statute that definitely needs to be considered whenever structuring a PSA. So the risk under the anti-kickback statute with a PSA is if the compensation that's being paid to the professionals for the services looks and feels like it is actually just the other party paying for a referral stream of services. So an example would be if a hospital contracts with a physician group to staff the hospital's emergency department, the concern is that the hospital will pay the physicians extra or that payment is influenced in order to get the physicians to refer more services to the hospital. So the theory is that the payment to the physician group gives the group an incentive that it wouldn't have otherwise had to order services and create extra business for the hospital. So there are some statutory exceptions to the anti-kickback statute. These are known as safe harbors. And if a payment falls within a safe harbor, then the payment will not violate the statute, regardless of the party's intent. So, unfortunately, these safe harbors are written extremely narrowly, and it is rare for a transaction to actually meet all conditions of a safe harbor. Luckily, though, a payment or a relationship doesn't have to meet a safe harbor in order to be legal. If a payment doesn't meet a safe harbor, then that would be analyzed on a case-by-case basis, and the facts and circumstances are examined to determine what the intent of the parties is. So this is where the government or a court will use the one-purpose test, looking to all purposes of the agreement to determine whether the payment truly is legitimate from all perspectives. Another way that parties could ensure that a PSA won't violate the anti-kickback statute is for the parties to seek an advisory opinion from the Office of Inspector General or the OIG to basically get assurances that the arrangement is compliant with law. And in seeking an advisory opinion, the parties submit to the OIG a description of the transaction. The OIG reviews it and then determines whether it would violate the anti-kickback statute. The good news is that if the OIG blesses the transaction, then the parties can proceed without fear of prosecution. So basically, it acts as an individualized safe harbor, for that specific arrangement. However, seeking an advisory opinion may not always be the most practical option for parties to a PSA. It can be expensive and it can be a somewhat lengthy process. That said, it doesn't mean that parties can't learn from and look to past advisory opinions that the OIG has issued. All of the OIG opinions are up on the OIG website. They're searchable, and so they certainly are helpful to review. Legally, the only persons who can rely on the advisory opinion are the parties who submitted the request to the OIG. No other parties can seek protection from the anti-kickback statute by pointing to an advisory opinion that was issued for different parties. That said, the opinions are still helpful in determining what the OIG's thought process is and what the OIG's reasoning is when analyzing a payment under the anti-kickback statute. So I think it's always useful to consider these past opinions when structuring an agreement, especially if you're going to have maybe different compensation terms or something that may not be kind of the traditional PSA. Okay, so there is a safe harbor for personal service agreements. And again, although you're not required to meet it, it is helpful to consider the safe harbor's conditions because it'll kind of give an indication of what the OIG considers important in structuring these agreements. So there are 7 elements. They are up here on the slide. I can go quickly through them. First, it has to be in writing, has to be signed by all the parties. The agreement must cover all services that the professionals will be providing for the term of the agreement, and it has to actually specify what services are being provided. The third condition requires the parties to specify the exact schedule on which the services will be provided. So this is, one of the elements where the parties can get a little hung up, since it's not unusual to have an agreement where the services will be rendered on an as-needed basis. For example, a physician group may not know with specificity exactly how often it will need to utilize the services of a contracted radiologist. And it might not make financial sense to have the radiologist just standing by on a regular basis or even on a scheduled part-time basis. So, this would be the situation, unlike the PSA arrangement where Jim was talking about, where it's a full PSA to the hospital. A group is just engaging a specialist on a case-by-case or more random basis. This would be a difficult condition to meet for those types of arrangements. The next element is that you need at least a 1-year term, and the services, or the payment for the services, must be fair market value. They have to be set in advance and can't take into account the volume of referrals between the parties. Again, this is another requirement that the payment be set in advance. That might not be practical depending on how the parties structure the payment terms. So the final 2 conditions of the safe harbor require the actual services to be legitimate and the amount of the services to be commercially reasonable. So again, you're not required to meet these conditions in order for a PSA to be safe from the anti-kickback statute. In most cases, if the parties can show that the payment for services is for fair market value and the services are actually, reasonably necessary, and that the agreement isn't just a sham to get the doctors to be generating referrals for the other party, then the agreement should survive anti-kickback scrutiny. Okay, moving on to Stark. This is the next big federal law that will affect how you structure a PSA. Stark prohibits a physician from making referrals for designated health services to an entity with which the physician has a financial relationship. Unlike the anti-kickback statute, which is a criminal statute, Stark is a civil statute. But just because Stark doesn't impose criminal penalties does not mean it's not important to keep in mind. Violation of Stark can involve penalties of up to $15,000 per service. Any claim that's paid as a result of any sort of prohibited referral is considered an overpayment. CMS is going to seek recovery and will require repayment of that overpayment. And you can also be subject to civil monetary penalties, up to $100,000 in connection with a prohibited referral. So it's very serious, and it's a very complicated statute. Also, unlike the anti-kickback statute, intent is irrelevant in the Stark analysis. So even if the parties have a completely legitimate purpose for their financial relationship, the referral is medically necessary and appropriate, it could still run the risk of violating Stark depending on the situation. So the first step in a Stark analysis in determining its applicability is to note that this prohibition applies to physician referrals for DHS. So if you have a PSA that doesn't involve any physicians, limited to non-physician practitioners such as physical therapists or nurses, advanced practice nurses, then Stark wouldn't apply to referrals from those parties. So, however, most PSAs do involve physicians, and so we would continue the Stark analysis. So next, we want to look at what types of services are being ordered by the physicians. In order for a referral to be covered by Stark, the services need to meet the statutory definition of designated health services. So up here on the slide is the list of 11 categories of DHS. It includes services, lab, X-ray, physical therapy. So you can see that these categories cover a broad spectrum of services. A key thing to remember, and I know this can sometimes get confusing, is that the PSA itself doesn't have to be for the provision of DHS. Rather, the question is whether a physician who's in a PSA with an entity makes a referral for DHS to that entity. So, it doesn't matter the type of services that are under the PSA. We want to look at what types of services the physician is referring to the entity. So finally, Stark only applies if there's a financial relationship between the parties. Two types of financial relationships, compensation and ownership, and then these can both be direct or indirect. In a PSA, we're looking at compensation relationships, not ownership interests or ownership relationships. So we would look at that for purposes of analyzing the arrangement under Stark. We look to whether it's a direct or an indirect relationship. Direct compensation relationships, pretty self-explanatory, basically exists if the entity is compensating the physician directly for the services. And the indirect compensation relationship, little less straightforward, basically has two-pronged definition. First, there's a chain of ownership relationships or compensation relationships between the entity and the physician. And then second, the physician's direct compensation must take into account the volume or value of referrals. A somewhat complicating factor in this analysis is the stand in the shoes concept that was implemented as part of the Stark Phase 3 rulemaking, I guess back in 2007 now, so it was a while ago. But what stand in the shoes means is that a physician's deemed to stand in the shoes of his or her physician organization. It's defined under Stark, but group practices are generally physician organizations under Stark. And you stand in the shoes of your physician organization for purposes of analyzing a compensation relationship. So If a group practice has a direct compensation relationship with a hospital, then the physicians of that group practice are deemed to also have a direct compensation relationship with the hospital. So typical PSA, the agreements between the hospital and the hospital pays the group the compensation. But because of stand in the shoes, the compensation relationship is analyzed as a direct compensation relationship between the physicians of the physician group and the hospital. And so we need to meet an exception under Stark if these physicians are going to be making referrals to the entity. And unlike anti-kickback statute, meeting an exception is mandatory under Stark. If you don't meet an exception, then it'll violate Stark. So this is just a kind of a visual of what I just explained, but basically you have an independent contractor physician group making a referral for DHS to an entity, like a clinic or a hospital, and then there's the financial relationship between that physician and the entity. In our case, it's the PSA. Okay, so we have a PSA. It's a financial relationship covered by Stark, and if the physician's making referrals to the entity, then it needs to make an exception. So there is an exception for professional service or for personal service arrangements, which is very similar to the anti-kickback safe harbor. The elements are up here on the screen, again in writing and signed by the parties. And this goes back to Jim's comment about having kind of a hard termination for the PSA. We see a lot of parties get tripped up on this because of the fact that they continue the relationship once the agreement itself has expired. There is a very brief kind of 6-month grace period, but usually and unfortunately the parties discover it much longer after the 6-month period has expired. So again, you need to specify the services. The term must be for at least 1 year. This doesn't mean you're locked into the agreement for a year, but if the agreement does terminate during the first year, the parties aren't allowed to enter into another agreement with each other that's the same or substantially similar to the original agreement until after that first year expires. So an example would be a hospital and physician group enter into a PSA. It terminates 3 months in. The parties would be prohibited from entering into another PSA or similar agreement until after 1 year has passed from the first agreement's effective date. So this is an important one to keep in mind, and I've seen people kind of forget about this requirement before. The amount of services covered by the agreement must be reasonable, and the compensation needs to be set in advance and consistent with fair market value. The requirement to have the compensation set in advance doesn't mean that the actual dollar amount needs to be specified at the outset of the agreement. The parties can agree on a formula, as Jim was mentioning, if you want to do RVUs or hourly rates. As long as you have the formula set in advance, you'll be okay. And then finally, you can't involve illegal activity. Okay, so one thing to keep in mind if you have a PSA that is not a, what I keep calling a full PSA, where basically the physician group has sold all of its assets to a hospital and then is, entering into a PSA with the hospital. But if you're doing more of a partial PSA where you're just doing limited services to a hospital, one thing to keep in mind is the group practice definition under Stark. So under Stark, there are very few exceptions that allow a physician group to own its own DHS, such as imaging and physical therapy, and the ability to basically refer to yourself physical therapy, imaging services. One of the exceptions that's most commonly relied on is the in-office ancillary exception. And this exception has many elements, one of which is that the group be what's known as a group practice as defined under Stark. So the Stark regulations provide that one element of the group practice is what's known as a substantially all test. And it's basically that substantially all of the patient care services of the physicians who are members of the group, that is at least 75% of the total patient care services of the group practice members, must be furnished through the group and billed under a billing number assigned to the group. And the amounts received must be treated as receipts of the group. So the key language to keep in mind in connection with the PSA is this underlined language, the and billed under a billing number assigned to the group. Because one of the, the common structure of a PSA is that the hospital bills for the services under the hospital's number, not the clinic's number. And so if you are entering into a PSA, that will result in the hospital billing more than 25% of the services under the hospital's number, you could have a problem under this group practice definition and basically eliminate the group's ability to take advantage of the in-office ancillary exception for purposes of doing imaging and other kind of in-house DHS. So the interesting thing about this is that there is language in the preamble to the 2001 regulations that seems to, or that actually does, kind of say the exact opposite of what the regulation says. So this screen shows what the preamble says, and I've underlined the key elements of this quote. But basically, it's saying if the group's business includes providing professional services to another entity, which then pays the group for these services, it's our view, and that's CMS, that these are services that should count as services a physician provides through the group. We're therefore interpreting the requirement that substantially all of a physician's services be provided through the group and be billed under a billing number assigned to the group and amounts so received treated as receipts of the group to include any physician's professional services billed by a group under any group billing number, regardless of the payer of the services, provided the receipts are treated as receipts of the group. So basically, the phrase billed under a billing number assigned to the group doesn't refer exclusively to Medicare or Medicaid billing numbers. So this is basically saying that you can ignore one of the elements of the group practice definition. It's very important to note here that this is preamble language and it is not the law. So even though it's basically interpretive guidance that the government issues, but it's not law. And even though you think that relying on interpretive guidance written by the government, interpreting its own regulations would be a relatively safe bet, we have definitely seen situations where that's not the case. And, and a court has ruled that the regulations or the statutory language trump any inconsistent guidance. So if you find yourself in the situation where you're entering into a PSA, but you still want to maintain the ability to bill for your own DHS by using the in-office ancillaries exception, it's very important to kind of keep the percentages in mind because you could eliminate your ability to be able to use the in-office ancillaries exception. Okay, the last thing to mention is just, in addition to any federal laws, it's also important to keep in mind what state laws are out there and state versions of the federal laws that may be the same as or may be more restrictive than the federal version. So for example, states may have their own versions of anti-kickback statute, kind of a mini anti-kickback statute that will apply to not just federal payers, but could apply to commercial payers or even self-pay patients. There could also be mini Stark laws that may have different exceptions or exceptions that are more difficult to meet. So those should also be considered. And then finally, fee-splitting laws that could affect the compensation that's being paid. These could be specific to a type of provider. For example, there may be a fee-splitting law for physicians, but there might not be one in that same state law. There might not be one applicable to nurses or to physical therapists. So it's just important to keep in mind that you shouldn't stop at the federal law, and you should consider whether any state laws are affecting the PSA and how you structure it. So I think that concludes the presentation. It looks like we have one question that Jim is going to field.
Actually, it's the best of all of the questions we've received, so we just have the time for this one. But feel free to email Katie or I if you've got some other questions. We'll try to get back to you. So the question is, what documents, sources do we recommend you use to determine fair market value? You know, the best thing to do is, frankly, to talk to a compensation consultant. Because this is a tricky area and there aren't a lot of books out there that are going to tell you fair market value. What is out there, though, are the physician compensation surveys done by a number of different organizations, MGMA and so forth. So you could start with a physician compensation survey that would give you an idea about what fair market value is to employ a doctor given, you know, a certain amount of productivity. But that's an employment model, and a PSA isn't employment. PSA involves oversight, management, recruiting, and you've got overhead. You've got FICA taxes, you've got, you know, benefits, and you've got other things you're doing. So the physician compensation surveys are a start, but then you have to build from there to come up with what I think would be fair market value for all of the services that the doctors are providing. And whether you could provide, you know, a margin there to compensate the group for supervising and recruiting and hiring and overseeing, that's where a compensation consultant can come in handy. You know, companies that provide physician staffing, like locums companies, they certainly have a margin in their business. So could a group under a PSA charge something in addition to the overhead and physician compensation amounts to reflect that additional staffing oversight? I think it could. But that's where a compensation consultant, in addition to that comp survey information, would be important. So with that, thank you for listening to our webinar, and we look forward to you participating next month. Thank you.
Thank you.